Hello, and welcome to today's session. Learning Outcome, LO3. Understand the rules on international arbitration and various alternative dispute resolution mechanisms. Today, we will explore a vital area of international business law: how disputes are resolved beyond traditional courts. In international trade, conflicts are inevitable, and businesses often operate across multiple legal systems. Traditional litigation can be slow, expensive, and complex. This session will examine arbitration and other alternative dispute resolution (ADR) methods, showing how they provide efficient, fair, and practical solutions to cross-border disputes. Arbitration is a formal process where parties submit disputes to an independent arbitrator. It offers a neutral forum, avoiding bias from national courts. Decisions are final, binding, and enforceable internationally. The process is confidential, focusing on commercial resolutions. Arbitration is governed by rules and treaties like the New York Convention. International arbitration relies on key legal instruments. The New York Convention ensures global recognition of arbitral awards. UNCITRAL model law harmonizes arbitration laws across countries. ICSID arbitration rules provide procedural guidance. Institutions like LCIA and SIAC are known for their expertise in arbitration. Party autonomy allows parties to decide arbitration rules and procedures. Neutrality avoids bias by providing a neutral venue. Confidentiality protects commercial secrets. Finality ensures that arbitral awards are binding. Enforceability under the New York Convention is a major advantage. The process begins with an agreement to arbitrate. A notice of arbitration is issued to formally notify the dispute. Arbitrators are appointed, and a preliminary meeting sets the timeline. Parties submit statements and evidence before a hearing. The arbitrator issues a binding decision enforceable under the New York Convention. Arbitration is independent of national courts and faster than litigation. It is confidential and awards are globally enforceable. However, it can be costly and has limited appeal rights. Enforcement may face challenges in non-signatory states. The lack of formal discovery rules can be a disadvantage. ADR includes methods like negotiation, mediation, and conciliation. Negotiation involves direct discussions to settle disputes. Mediation uses a neutral mediator to facilitate settlement. Conciliation is similar to mediation but may propose terms. Expert determination involves an independent expert's decision. Arbitration is binding, while mediation and conciliation are not. Mediation involves a facilitator, whereas arbitration involves a decision-maker. All methods maintain confidentiality. Arbitration is more formal than mediation. Costs and speed vary, with arbitration generally being more expensive. Arbitration and ADR avoid jurisdictional conflicts and ensure enforceability. They preserve business relationships and encourage faster resolution. Most international contracts include a dispute resolution clause. This clause provides clarity and predictability. It aligns with frameworks like UNCITRAL and ICC for consistency. The rules of arbitration and ADR maintain confidence in global trade. Arbitration provides a neutral and enforceable framework. ADR methods promote early settlements. Harmonization through conventions ensures fairness. This blend safeguards legal certainty and business relationships. Arbitration and ADR are essential for international trade. They provide neutral, enforceable, and efficient dispute resolution. Harmonization through conventions ensures global consistency. This framework supports sustainable global trade. Understanding these mechanisms is crucial for international business success. International contracts often involve parties from different countries. Determining the governing law is crucial. It affects rights, obligations, and remedies. A clear choice of law clause reduces uncertainty. Without it, costly jurisdictional disputes can arise. Governing law regulates contract formation, validity, and interpretation. It determines what constitutes a breach and available remedies. Procedural law governs dispute resolution methods. Substantive law defines rights, while procedural law enforces them. Both are distinct but related in contract disputes. Contracts often include a governing law clause for predictability. Without it, conflict of laws rules apply. Express choice is straightforward, agreed by both parties. Implied choice is inferred from contract terms. Closest connection test applies when no choice is evident. The Rome I regulation applies to EU contractual obligations. CSD provides rules for international sale of goods. Lex Mercatoria covers international trade customs. These frameworks ensure consistency in governing law. They reduce conflicts between different legal systems. Governing law defines rights and obligations. Jurisdiction determines the forum for disputes. An international contract may be governed by one law, but arbitrated elsewhere. Procedural law governs arbitration procedures. The two are distinct in resolving disputes. Choosing the right governing law ensures certainty and enforceability. It avoids home court advantage perceptions. Harmonization reduces legal conflicts. Parties often prefer laws like English or New York law. These are known for predictability and neutrality. Case law illustrates the application of governing law principles. Courts uphold express choice unless against public policy. Implied choice relies on contract terms and forum. Closest connection tests apply when no choice is evident. These principles guide contract interpretation. Governing law determines rights and obligations in contracts. A clear choice of law clause avoids uncertainty. Frameworks like Rome I and CISD guide law application. They ensure consistency and fairness across jurisdictions. Choosing a predictable legal system builds confidence. Governing law is crucial in international contracts. It ensures certainty, enforceability, and fairness. Harmonized frameworks guide its application. Predictable legal systems like English law are preferred. Understanding governing law principles is vital for contract success. Mediation is a key alternative dispute resolution method. It offers a confidential and flexible process. A neutral mediator helps parties reach a settlement. Unlike arbitration, it does not impose a binding decision. Mediation preserves relationships and reduces dispute costs. In conclusion, mastering these principles is essential for ensuring the success of global transactions. If you have any questions, please don't hesitate to get in touch via text or phone at 07000 484 361,688. I appreciate your attention and look forward to seeing you at the next session.